really big case is Fulton versus City of Philadelphia. This is a monumental case and highlights why John Roberts frustrates conservatives, way more so than the Obamacare case. This case highlights why conservatives get really frustrated with John Roberts, who gave them exactly what they wanted without the doctrinal shift they wanted. So the Fulton versus City of Philadelphia case is a bizarre kind of case. It's one that should have never made it into the court system. We're in Pride Month now, and there are a couple of things that you should be paying attention to. This was a case that gay rights activists brought to punish Christians for upholding their biblical sexual ethic. Catholic charities cannot adopt to singles or gay couples. It is the long-standing tradition of the Catholic Church for 2,000 years, believe it or not, that marriage is between a man and a woman, and that a two-parent heterosexual household is where children belong. You can disagree with that. I'm not here to argue the merits of this with you. Don't hear me saying I'm arguing the merits on this. I'm just telling you what the Catholic Church believes. Whether you believe it or not, it's what the Catholic Church believes. And consequently, the Catholic charitable organizations adhere to Catholic biblical sexual orthodoxy, which is also Christian biblical sexual orthodoxy. You got 2-3 billion Christians 4 billion Christians on planet Earth, and 3.9 billion of them all believe the same thing. I mean, I guess if I'm including Episcopals in that number, I'm not sure I should, but nonetheless, you've got this idea that now on the left, that if you take any money from the government or you participate with the government, you must abandon all of your beliefs for left-wing doctrine. So the City of Philadelphia told the Catholic Church, you can no longer help foster kids, nor can you participate in adoptions in the City of Philadelphia. And the Catholic Church sued and said, the First Amendment gives us the free exercise of religion. We are exercising our religion. We should not be precluded from participating with the state when the Constitution allows us to exercise our religion. A 9-0 Supreme Court, 9-0, agreed with the Catholics. Now, here's the thing you need to understand. There had been a massive amount of left-wing hysteria that Sam Alito was going to write the decision, and it looks like there had to be some machinations behind the scenes given the way the case came down. But the bottom line is that despite all of the hysteria from the left, that the conservatives were going to get rid of employment versus Smith, the Smith decision, they did not. And I got to touch on that here in a minute, and I need to explain that one to you. But they didn't do that. They did, however, unanimously agree that there was an affront to religion. Now, how did they do that? So there's this thing called strict scrutiny. And strict scrutiny means that when the courts or the government, when the government decides to impact your rights, if they're fundamental rights under the Constitution, strict scrutiny must be applied. That means the government must have a compelling, overarching reason to impact your rights. In essence, the government can never reach the compelling decision. There's never been a case where the government, under the strict scrutiny standard, has been able to curtail your rights. Now, the reality is that the First Amendment, there's a more nuanced approach to the First Amendment. And some rights can be impacted with less than strict scrutiny. But in a situation like this, there's long settled Supreme Court reasoning that if a government is allowed to pick and choose who can participate in a program and can set requirements, but then waive those requirements for some, the government will be under strict scrutiny for when it decides to waive the requirements for some and not others. In this case, the City of Philadelphia said the Catholic Church must surrender its biblical 2,000-year-old sexual orthodoxy in order to participate in foster care programs, but allowed other groups to participate in foster care without adhering to all the requirements. And so the Supreme Court determined it was, in fact, discrimination against a Catholic group to allow other groups into the program without having to give up things that otherwise would have put them in conflict with the program. But the Catholics had to give up their religious doctrine in order to participate. It's clear discrimination. And John Roberts was able to write the decision and get a 9-0 Supreme Court decision. No one saw a 9-0 decision coming. No one, on the left or the right. In fact, the prevailing consensus among everyone is that it would be a 5-4 or 6-3 decision in favor of Catholic Charities, and it would strike down Smith. John Roberts was able to get the outcome he wanted without striking down Smith. Now we must discuss the Smith case. You've got to understand what's at play here so that you can understand the future of where this goes and where the arguments are going to head when it comes to Smith. The Smith case is an employment discrimination case from the 1990s. And the Smith case was written, I believe, by Justice Scalia. Essentially what it held was that if the government has a neutral rule that applies to everyone, even though it conflicts with religious doctrine or imposes an undue burden on a religion, the religion must adhere to the neutral rule. I'm pulling up this decision again. This is from the Supreme Court. It was decided in 1990. It was decided by the Rehnquist Court. And I believe, who wrote the decision? Yes, Antonin Scalia wrote the decision. This is the decision that Antonin Scalia later regretted writing. Essentially, he said that the court never held that an individual's religious beliefs excuse him from compliance with an otherwise valid law prohibiting conduct that government is free to regulate. Allowing exceptions to every state law or regulation affecting religion would open the prospect of constitutionally required exemptions from civic obligations of almost every conceivable kind. For example, compulsory military service, payment of taxes, vaccination requirements, child neglect laws, etc. That was from 1990, and ever since, the left has used the Smith decision to impose more restrictions on religious people in the government sector. So if you engage with the government and you're religious, you have to give up portions of your religious beliefs. And Christians have long agitated that something needs to happen with this case. Sam Alito today in the Fulton case basically said it's time to overrule Smith. Amy Coney Barrett, interestingly enough, along with Stephen Breyer of the left and Brett Kavanaugh, argued that, yeah, we got to do something with Smith, but we can't get rid of it. We need to modify it. Here's what Amy Coney Barrett wrote. And again, Justice Breyer of the left agreed with them. I'm skeptical about swapping Smith's categorical anti-discrimination approach for an equally categorical concurring strict scrutiny regime, particularly when this court's resolution of conflicts between generally applicable laws and other First Amendment rights like speech and assembly have been much more nuanced. In other words, Amy Coney Barrett and Brett Kavanaugh and Sam Alito and Neil Gorsuch and Clarence Thomas want to get rid of the Smith decision. The question is how to get rid of it. Thomas and Alito and Gorsuch, it sounds like, just want to throw out the decision altogether. Coney Barrett and Kavanaugh and Breyer don't want to throw it out altogether, but want to be more nuanced with it. So for those of you who are confused by everything I've said here, let me give you a more general synopsis, because I don't want to overwhelm you with this decision, but it's a really big freaking deal. A 9-0 Supreme Court today said that states cannot discriminate against Christian adoption agencies who want to participate in foster care. That's a really big decision. Everyone from Sonia Sotomayor to Clarence Thomas agreed with this decision. The case, though, settles it for Catholic Charities in Philadelphia, but also opens a bag of worms in the future of how do you guide this forward. Sam Alito said the opinion today might as well have been written on the magic disappearing ink paper from a magic shop. Because unless you deal with Smith, these cases are going to still come up. And thus, we have to deal with Smith. Smith says the government, if it passes a law that is generally applicable, can impose on religious people, even if it forces them to give up their deeply held religious beliefs. A majority of the Supreme Court today says it's time for that to go away, but we don't have the answer for how to do it. So this issue is still going to be coming up. And thankfully, a majority of the court is headed in the right direction with this. This is a monumental case in the Supreme Court today. Now, it's more monumental than the Texas-California case. And again, in the Texas-California case, the Supreme Court threw out the Texas lawsuit over Obamacare, but did so on standing grounds, not on the merits of the underlying case. Frustrates a lot of conservatives, but it was notable only Gorsuch and Alito wanted to hear the case. Even Clarence Thomas supported throwing the case out. So there's still a fight to be had there. But the Fulton case, nobody saw a 9-0 decision coming. Now, here's the other side of this. Everyone expected Sam Alito to write this case. John Roberts has a lot of faults, but one of the geniuses of John Roberts is he is a master manipulator of the Supreme Court rules. Roberts gets to decide who writes the decisions. And there are a hell of a lot of people smarter than me out there today who have read through this 100-some-odd page decision with all the concurrences. There are a lot of people who have digested it and said you really strongly get the sense that John Roberts wrote a very narrow decision and essentially told the Supreme Court, if you don't go along with me on this, Sam Alito's going to write it and you're going to have hell to pay because he's going to throw out Smith. Essentially, Roberts told the left, either we have a unanimous decision to support Catholic charities in America who've been doing this for over 100 years, or I'm going to let Sam Alito write the majority opinion and y'all aren't going to get anything. Roberts was able to cobble together this 9-0 decision by threatening the left with Sam Alito, and it worked. That seems very clear to my reading and the reading of a whole lot of people way smarter than me, that Sam Alito has the votes to get rid of Smith, and it was by John Roberts' grace he manipulated a 9-0 decision to give everybody on the right what they wanted without shifting doctrine so that the left couldn't sign on to it. He just got the liberals on the Supreme Court to agree you cannot discriminate against Christian adoption agencies in this country. I'll take that win, and so should you.